Welcome to Zero Trust, Encryption and Other Approaches to Protecting Private Data and Communications. This is the second of a free three-part webinar series presented by the American Bar Association, Civil Rights and Social Justice, or CRSJ, and Science and Technology Law Section, SciTech, to boldly explore digital threats to the right to privacy. My name is Ruth Hill-Bro, and I'm a past chair of the SciTech section and a special advisor and immediate past chair of the ABA Cybersecurity Legal Task Force. SciTech and CRSJ have jointly developed today's program and the three-part webinar series to bring together thought leaders, highlight best practices, and identify next steps in an area where change is the only constant. Now visit ambar.org/encryption for updates on and recordings of these programs and related materials and resources. Now, during today's 60-minute program, we encourage you to ask questions of our panelists through the Q&A, not the chat function. If you don't see the controls at the bottom of your screen, please ensure that your screen isn't idle. I will monitor the Q&A, and the panelists will do their best to address your questions, time permitting. We'll share a recording of this program with everyone who is registered so that you can share it widely with your networks. And as we get underway, I'll provide the usual disclaimer that goes with the titles I'm about to give you, that the views expressed here by the panelists are their own and not necessarily those of the entities for whom they work or have worked, and none of their comments should be construed as legal advice. Now I'll introduce our moderator, Lucy L. Thompson. She's a founding principal of Livingston PLLC. She is also a past chair of the ABA Science and Technology Law section and serves with me on the ABA Cybersecurity Legal Task Force, as does our other panelist, Eric Hibbard. And she is an editor and author of many articles and books, including the ABA Data Breach and Encryption Handbook, and a contributor as well to our most recent task force book, the ABA Cybersecurity Handbook. Eric Hibbard is Director, Product Planning for Storage, Networking, and Security for Samsung. He's a council member for the SciTech Law section and works on a gazillion different standards organizations. So we are so lucky to have him. And then we have Susan Landau, Bridge Professor in Cybersecurity and Policy for the Fletcher School and School of Engineering, Department of Computer Science, Tufts University. She's written extensively in the field, including specifically on this encryption debate. So thank you so much, speakers, for being with us. And now I'll turn the program over to our moderator and panelists so we can get those insights on the cybersecurity landscape.
Welcome, everyone. The first panel in this series discussed the digital privacy threat landscape and how it has changed post-Dobbs. Personal communications and confidential information, including healthcare records, that individuals assume is usually protected under HIPAA, is being leaked and used in some states to prosecute doctors and women seeking abortions. That's one of the key points from the panel in the first webinar. And they also said that prosecutors in some states where abortion is legal are trying to obtain communications and information posted online by women who are trying to obtain abortion medication from providers in states where abortion is legal. So these are a few of the key problems that need to be addressed, and the reason for this webinar. Solving the problem of how to protect personal and confidential information, communications, and records is quite complex, requiring a careful analysis of the legal and policy implications and the practical capabilities of available technologies such as encryption. From a technology perspective, it requires a deep knowledge of the available mechanisms to secure communications and data. Our two preeminent experts on this panel are here to provide not only some of the answers, but also to suggest the right questions to ask. They will address the challenges and practical questions of whether and how encryption and other security mechanisms can and should be implemented or mandated widely. So thanks for the audience for already starting to put questions into the Q&A. And I see that the panel has already started to answer them. So we'll do that as we go along. So we're going to start with a look at the current state of the encryption debate and begin with a high-level overview of encryption to be sure that we're all on the same page. So Dr. Susan Landau, who has graciously said we can call her Susan, is going to start by telling us what is encryption, how does it work, and what information can be protected with encryption.
Thank you very much, Lucy, and I very much appreciate being here. So encryption is a way of hiding information when you either keep it at rest, data at rest, or you communicate it, data in motion. And it consists of two things. It consists of an algorithm and a key. So let me give some very simple examples for those of you who've never thought about the issue before, although I'm sure that everybody did when they were small children. And the example that we all start with is the Caesar code, where you take the alphabet and you shift it a couple of letters, a few letters. So if you shift the alphabet, say 2 letters, so you take the letter A and you move it, you encrypt it with the letter C, the letter B with the letter D, the letter B is C with the letter E. That is, I'm taking each letter of the alphabet and moving it 2. The algorithm is shift and the key is 2. Now, that's a pretty easy algorithm because there are only a few ways you can shift. You can shift up to 26 different ways. You can shift by 1 letter, 2 letters, 3 letters. If you shift by 26 letters, you get back to where you started. It's very easy to break a Caesar code. A slightly more complex algorithm is the substitution cipher, where you take a letter and you substitute a different letter. So you might take A and substitute T. You might take B and substitute F, you might take C and substitute K. You can pick any letter that you haven't already used. You then have 26 choices for the first letter, 26 different ways you could substitute for A, 25 ways for B, 24 ways for C. And those of you who are pulling out your calculators can probably figure that I've gotten a very big number. We call it 26 factorial, 26 times 25 times 24 times, and so on. It's in fact very easy for a trained cryptanalyst to break such a system, because if you play Scrabble, for example, you know that E is the most frequent letter in the English alphabet, and it appears 13% of the time, T next, and so on. You do a frequency analysis, and you can break a system. A trained cryptanalyst can take a message, an encrypted message of 25 letters, and actually break a substitution cipher. I could go through more, but all I wanted to do was give you a sense of what is the algorithm and what is the key. So in a substitution cipher, the algorithm is substitute. The key is what letter does A get mapped to, what letter does B get mapped to, and so on. The interesting thing in cryptography, the revolution that's been around almost a half century now, is public key cryptography, which is the idea that you can share the key publicly, but still make a secure system. What I mean by this, it used to be the case that if Eric and I, for example, wanted to communicate privately, I would have to go over and hand him the key, or I'd have to find a trusted messenger to give him the key. But what if I'm trying to do commerce over the internet or something like that? What if I'm connecting to Amazon for the very first time? How do I get a key to protect my credit card? And that's public key cryptography, which was invented in the mid-1970s. And it's revolutionized everything, including internet commerce.
That's very helpful, Susan. Thank you. Since we're talking about protecting communications, records, and information on this webinar, I want to ask Eric, what's the difference between protecting communications as compared with data at rest? And are they different?
Yeah, they're definitely different, and even the algorithms that get used and the mechanisms that get used are different. So think of communications. You effectively have two parties, two endpoints, and and back to this issue of a key. First, you have to agree on what algorithm that you are both endpoints are going to use, And once you've done that, you know essentially how you're going to protect the data. But then you have to agree on a common key. There are other mechanisms, but that's probably the most common. So there's a lot of setup that takes place. Those of you that are used to buying stuff on the web, you know, this is the initial handshake that may cause you a slight delay while those calculations are basically done. But basically, it's a key agreement and algorithm agreement, and then once that's done, you'll typically switch to a different type of encryption that's a little more efficient, because this public key encryption can be computationally intensive. So, but what's important here is both endpoints are participating. They both have to be able to encrypt and decrypt. From at-rest perspective, you typically have what we call a point of encryption. So the data comes in, it's in the clear. It comes to this point of encryption. An algorithm with a key is basically run. And what comes out the other side is what we call ciphertext. It's basically the encrypted data. And that is then proceeds down to some sort of storage, or you could actually ship that across communications. But what you're moving now is the encrypted data, or the cipher. So, in one case, you've got basically two parties have to basically know. The other one, essentially, you have this single point where this encryption is taking place, and that's where the key has to be known. Now, anybody who has access to that key and access to that point of encryption, has the ability to get plain text data. I know that's an oversimplification, but basically that's the difference between the two.
So let's talk about data breaches. Are there opportunities for data breaches when the data is unencrypted for processing? And also, what about protection of the key? Can that lead to data breaches if it's not protected?
Short answer, yes. In fact, the handoff between if you've got communications encryption and at-rest encryption, there's basically a gap between those two, and so that's a potential interception point. Mishandling the key management is really a potential area of exposure. The algorithms themselves tend to be considered unbreakable, but the actual implementation, the handoff between different forms of communications versus at rest, and sloppy key management are two areas. And Susan, I'm sure you've got some additional comments on this as well.
Well, I would say the whole issue of key management is the hardest issue when you're talking about security. But of course, as Eric will give you many examples, encryption is only one piece of security. You have many aspects to security. But that's why the whole issue of key management is why public key was such a revolution back 50 years ago, because it enabled people at a distance to all of a sudden communicate securely without having communicated previously. But I'll stop here because you have a lot of interesting questions to tackle.
Great. Well, Susan, you've been very influential in the encryption debate for many years concerning whether law enforcement should have access to encrypted data on computing devices. And you've written documents with wonderful names called Keys Under Doormats, for example, and Bugs in Our Pockets, and other important articles and blogs. And members of the audience can find those on the program website. And you've been involved with the National Academy's studies of the encryption issues. So please give us an overview of the debate and tell us about the positions of various stakeholders over the years.
And how many years do I have to answer this question?
Yeah, right. A few minutes.
So the debate has been publicly going on since the mid-1970s, since the invention or discovery of public key cryptography. And originally, the NSA objected to the publication of research in this area and tried to shut that down. That quickly stopped. Then the NSA tried to grab hold of the ability to provide encryption algorithms for the non-national security agencies of the United States. That sounds like a very obscure issue, except it's not, because NIST, the National Institute of Standards and Technology, does the development of these standards. And because NIST is in the Department of Commerce and has trusted relationships with industry, the standards are not only used by the non-national security agencies of the US government, but they're often used by private industry, not only in the United States, but around the world. And that was much less likely to have happened had the NSA taken over that development. The next thing that happened, and that was where it really broke into the public space, was export controls on encryption. And the NSA and FBI were very closely aligned on this. There were fights during the 1990s. And the NSA didn't want to see governments and companies abroad having access to strong encryption. So it liked the export controls. The FBI, on the other hand, noticed that if you have export controls, then you don't get use of strong encryption domestically, because companies can't easily say to customers abroad, you get encryption with short keys, but domestically they get them 4 times as long, which makes it much, much harder to break. That didn't work. And so the export controls limited use both domestically and abroad. The NSA changed its view in the late 1990s for a variety of reasons, including the fact that other nations were now using strong encryption, and not just the technologically advanced ones, but also the less technologically advanced, because it became easy to do so. And the NSA also saw other things it wanted to do, so it made a trade with the White House, essentially saying, you give us funding for computer network exploitation, all the things that Snowden revealed a dozen years later, and we'll back off on the encryption debates. The FBI was not happy about it and hasn't been happy about it for the last 20 years, 23 years, and has been arguing that it is going dark. Notably, the NSA has not been publicly supporting that statement. And in fact, you have many senior, ex-senior officials of the NSA and other agencies, including the General Communications Headquarters of the UK, saying that the use of strong encryption widely by the public is important for national security, business security, and so on. So that's it in the 5-minute version instead of the 2-hour version.
Oh, that's excellent. The audience can read your articles and learn more. But let's talk about the countervailing considerations that law enforcement has. Obviously, individuals and companies want to and need to protect their confidential data and communications, but law enforcement have legal responsibilities to investigate and make cases pertaining to pornography and child sexual exploitation of and abuse, and combating terrorism. So what are the, based on your discussions with other experts in law enforcement, how important is it that law enforcement have access to the encrypted data on the computing devices?
So that's a very broad question, and it depends on the type of crime. It depends what you're investigating. It depends all sorts of things. But let me start by saying that the NSA was happy or satisfied with the trade-off it made back in 2000. That doesn't mean that the NSA does not have strong decryption capabilities, and we know that it uses them, but it also has found on many occasions that just knowing who is communicating with whom when often gives the agency, the signals intelligence agency, the information it wants, and what the people say is less important. Now, law enforcement is doing a different kind of job. They have to convict somebody rather than just figure out what somebody is doing. But there's lots of other kinds of tools. We are littering the radio waves with all the information about us. So the communications metadata is particularly rich, as is, for example, telemetry, the information on your phone that helps orient your phone straight. The screen on your phone, it helps the proximity detector, which makes sure that when you put the phone up to your ear, you don't press buttons and disrupt your call, the battery sensor. That information is often reported off the phone. You mentioned Dobbs earlier, and the Dobbs decision, we all know to shut off GPS if we don't want to be tracked by an app. But in fact, the accelerometer, gyroscope, and magnetometer, that telemetry information that helps orient the screen on your phone, or that allows you to use a mapping application, that can also be used to track you not only to a building, but which medical office you went into in that building, which floor of the building you were in, and so on. There's other data from the phone that comes off that can do that. Law enforcement uses automated license plate readers. They use all sorts of information. So in one sense, what law enforcement has been asking for is the ability to do 20th century investigations, that is, investigations where you get the wiretap information in the 21st century, and hasn't adopted sufficiently to the 21st century. But there are plenty of other tools law enforcement does need and has gotten better in the last decade at using these other kinds of information sources. This is not to say that content isn't useful. Content is often extremely useful and may provide exactly what you need, but there are other forms of data that can be used.
Well, during the Apple debate, when the FBI said it needed data on the Apple phone, James Comey, who was then the FBI director, took a fairly public position about the need for a backdoor. And so what's the current position of the FBI director, Christopher Wray? Have you heard?
Yes, no, they continue to argue. They say we don't want a front door, we don't want a back door. We just want the capability when we have a wiretap order to be able to go in and get the data. The problem is that there's no technology that anybody has ever come up with that says, we'll let the good guys in to access data and the bad guys will not be able to break in. When you build a system that is accessible for the good guys, it's going to be accessible for the bad guys. So FBI wants Silicon Valley to tech harder. And Silicon Valley's response is, you can't do that. There's no thing that says, oh, you're a bad guy, we can't let you in. You're a good guy, got a law enforcement warrant, we'll let you in. And so law enforcement hasn't changed its argument, but it hasn't had national security backing it up. And instead you see former heads of NSA, as I said, former head of GCHQ, the British version, and so on, arguing that end-to-end encryption and securing devices is really important for not just private individuals, but national security, business security, public safety. One of the things about all of this is that when people find it easy to encrypt their communications, encrypt their data, then we lower the incidence of crime. We don't make it zero, but we are taking safety measures that are necessary.
So there you have the debate. So now we're going to ask Eric to tell us what's the current state of the law in the US and internationally, and also from the standards organizations. So let's start with the current US laws and regulations. How broadly is encryption already mandated, and for what industry sectors, or who's covered?
So from a US perspective, I would say that the coverage for the use of encryption is pretty active in the healthcare arena. That's the one, and I guess maybe the easiest way to sort of characterize this is it seems that privacy, which has a sort of a regulatory legal background, is serving as a pretty serious catalyst for introducing specific requirements around the use of encryption. Lots of businesses are using it because it's a good practice, but where it's being mandated is typically around healthcare. We're seeing again needs to protect consumers and consumer information, personal information. Again, if you look closely at that, the driver is coming from a bit of a privacy angle on that. So from a U.S. perspective, that's definitely what we're seeing. If you go beyond the U.S., again, the privacy angle is a huge issue, especially, for example, in Europe. But it's not limited to Europe. We're seeing in Japan and Australia, China, even Russia have lots of requirements around privacy, which basically forces the use of different types of encryption. We're also seeing, again, back to the U.S., if you're doing things with critical infrastructure, there are definitely requirements. They vary a bit on protecting that kind of infrastructure, so both communications and at rest. But in general, the use of encryption is not necessarily mandated, but I would say if you're foolish enough not to use it, the legal community is likely to reward you for that failure.
That's good. So you provided us with a wealth of information about the standards that you work on for ISO and other organizations, NIST standards. The audience can have access to 65 publications that you provided that all pertain to encryption. So tell us about some of the themes that are included in these documents.
So as we were talking earlier about the encryption of data in use or at rest and in flight or in motion, work in that area continues. One of the new themes, new relative to the history of encryption, is now trying to protect data in use. So we're seeing the emergence of encryption technologies to help with dealing with that. The United Nations has put out an interesting white paper that covers privacy preserving computing technologies. There's a couple of things in there worth mentioning. The use of trusted execution environments, and think of these as sort of black boxes. Everything in is protected. The open calculations are basically done in this black box that there's no exposure outside of it. And then everything coming out is basically encrypted. The other one is, for example, fully homomorphic encryption, where the data is actually being encrypted and you're performing operations on the encrypted data. In other words, the party that's doing the calculation of the operation never has visibility into the data. Both of these require lots of specialized hardware. They can be, in the case of homomorphic and fully homomorphic encryption, can be computationally intensive. DARPA is right now funding research where they want to make the homomorphic calculations to be 1 million times faster than they are. But if they're able to do that, then essentially you would never actually move plain text data, or at least certain types of plain text data. So those are some themes. I guess another one that's worth mentioning is how to deal with quantum computing and where that's going to take us. And in the case of symmetric key, single key encryption, what we're seeing, the protection there is just double the size of the key, and that effectively deals with the problem. The asymmetric stuff where Susan was talking about public keys and private keys, the general perception is this is all broken, at least for the current algorithms. And so we're coming up with whole new algorithms to essentially deal with that problem, because if we don't, and quantum computing becomes available to certain parties, then essentially most communications would be vulnerable. I would say that there are certain organizations around the world who are already capturing current streams in anticipation that quantum computing will be available, and for high value targets, they'll go back and sort of review what has already happened in the past. But there are certain kinds of data, certain communications that are going to be valuable 10 or 15 years from now, and when we get to that point, we're likely to be able to see some exposures on those things.
I should say that
Yes.
that happened, of course, during the Second World War. The US collected against the Soviet Union, and 10 years later was able to uncover spies as they broke the systems and discovered, for example, the Cambridge Five and others.
Yeah, and that's I mean, just sort of piggybacking on what you're saying, Susan. Yeah, we appear to have entered that era again, where the threat of what quantum computing is going to be able to do, it does have some of these players in various countries already harvesting and storing data. I mean, the amount of data that is being collected and preserved is phenomenal. It's measured in exabytes. So it's those of us that work in the storage industry, it's a good time to be selling to some of these players.
So looking to the future of computing that you started talking about, Eric, one of our past SciTech chairs, Ray Ocampo, asked, what are the implications of AI? And is that going to make it easier to break encryption and the keys?
So I don't think AI is necessarily going to make it all that much easier, although some of these new algorithms that we're working with in sort of the post-quantum crypto kinds of areas, I could see AI potentially being used to try a whole range of attacks that a crypto analyst might not be able to do. Where I think that AI, and in fact, AI is already an issue that we deal in the security world, both in terms of defense as well as the attacks. So it's definitely a tool that we're seeing to essentially probe the implementations. And as Susan and I both pointed out, things like poor key management, poor key selection, poor key generation, those kinds of things could in fact be discovered with with AI that's sort of focused on the right aspect. In terms of breaking the algorithms, not so much. Poor implementations, oh my God, it's already happening now. We're already seeing AI being used at.
The only way I would I agree with 98% of what you just said, Eric. The only place I would disagree slightly is AI is going to make it easier to do a certain amount of coding. And so we may see more efforts, but that's at the very margin. I don't think it's going to have, I agree with you.
That's good.
Eric, in these laws that you discussed in standards, are there specific mandates for encryption, or is it just an option in connection with organizations' risk assessments and the development of their security plans?
In general, it's tracking risk assessment kinds of things. I think the one area in the U.S. that's worth noting, because many vendors have to deal with this, is if you're using encryption to protect sensitive U.S. government information, which is just about everything that they're touching. If you look kind of how they're doing it, they're requiring certain certifications of that cryptographic technology so that it can actually be used there. So, and if you're familiar with the FIPS 140 program, we're on -3, which is the third generation of it. So products that are going to be used in the protection of data must be certified, not capable, not compliant, but actually certified before they can be used in those environments. Now, the reason that's important is what we see are certain states. That's kind of an easy thing to point at. Well, your product needs to be certified, whether they know what that is or need it, and then we'll see that sometimes that gets sort of pointed out. The specific algorithms and key sizes and things like that, we usually don't see, and that would be kind of a problematic anyways. If, for example, if you were mandating a particular algorithm and then post quantum that algorithm is not acceptable, then you've got a huge problem with your regulations. So it's usually as loosely as reasonable security, which is something I kind of giggle about. But then And then the other side of it is a risk-based, which means you've got to do your homework. You got to understand what you're protecting and what the issue. And it's not about just the encryption. I mean, you can do the encryption piece is the easy part. It's how do you manage the keys, short-term, long-term, with all of the community that you deal with. And so the regulations often don't deal with the key management piece if they have anything at all in it.
And
So
here I would just
Go ahead.
add one thing to what Eric said, which is we've only seen one or two breaks of the mathematics of encryption over the last 20 years. That is encryption that has risen to the point of being a standard. When there's a competition, we find lots of breaks as we try different algorithms. But so very few breaks in the mathematics of the encryption. We've seen breaks in the protocols, the proposed methods of employing the encryption, sometimes after the protocols have been in use for 10 years. Where we see most of the problems, of course, is in the implementation. So you go from a mathematical algorithm, the encryption, to the protocol, to the implementation, and the breaks are all at the implementation end.
Absolutely.
So, Susan, you've been involved in discussions about what available technology options there are for the protection of personal and confidential communications and encryption options. So could you please tell us about those discussions that you've had with the experts and what are the issues and concerns that they have?
Well, most of the concerns that they have is that they won't be able to wiretap. And it really is a law enforcement issue about not being able to wiretap. For users, you use a commercial product. You don't go and find some friend, even a very smart friend, to roll the product for you, because that won't work. You go, you buy a product from a trusted company or a free product from a trusted source, but you don't roll your own encryption. You don't try to come up with your own system. Anytime somebody suggests that, you know that they're selling snake oil and it's time to move on. When the changes in export controls happened 20 some years ago, those of us in the business expected to see consumer products with strong encryption available right away. That didn't happen. It began happening in the mid-2000s after Apple introduced the iPhone and discovered first that people were stealing the phones, and then they instituted Find My iPhone, and Android instituted something similar shortly afterwards. Then they discovered that stolen phones were a very good source for data for identity theft. And so you had to protect the data on the phone. And that's when you got to locked phones, which is what upset the FBI. It's only been post-Snowden that we finally saw widely available encryption products for communication. And that has been making its way into the very public marketplace, because you see Facebook and such companies now offering such products.
Well, what's the issue with the availability of encryption at scale? We were talking about this the other day. Could you just tell us what the issues are there?
For a long time, law enforcement would say the problem was doing organized crime investigations, drug investigations. For a while, they talked about kidnapping. They've always talked about terrorism. But as I said earlier, often knowing who is communicating with whom when gives law enforcement a lot of what they need to know. It certainly gives national security a lot of what they need to know in the case of terrorism investigations. More recently, law enforcement has been arguing that child sexual abuse material, photos and videos of children being abused sexually, are impossible to investigate without access to the content of communications. It turns out that the child sexual abuse material question is actually a much broader one. It's one that the experts will call child sexual abuse and exploitation, and involves 4 different kinds of criminal activity. It involves sharing of photos. It involves photos. Now, this is hard for people our age to imagine, but young people, including very young people in their teens, below age 13, 14, take photos of themselves in compromising ways, share it with friends. Then those friends stop being friends and maybe share the photos elsewhere. Or sometimes some criminal person is able to get access to the photo and then compromise the child by saying, send me more of these. That's called perceived first person sexual material. There's also real-time video abuse of children, and there's sex trafficking. These crimes are all fairly different, and they're investigated and prevented in different ways. Lumping them all together makes the whole discussion about encryption very difficult. There's also aspects of it that people don't realize. So that, for example, Facebook, when it shared data with NCMEC, the National Center for Missing and Exploited Children, which is the agency, the non-governmental agency that collects this data and shares information with the government, when Facebook shared this information in October and November 2021, they found that 90% of the photos that they were sharing were essentially the same 6 photos. So it sounds like a huge amount that they're providing, and then it turns out it's the same 6 photos. Now, those 6 children, or maybe there were more than 6, but those 6 are exploited and so on. But there's another side to this, which is really weird, which is that apparently 75% of the people who share these things do so because they're outraged about the photos or because they find them humorous. So there you're talking less about being able to do an investigation and more about educating people about the harm they're doing by sharing the photos, even though they're not voyeuristically interested. So this is in crunching it down to saying we need to access encrypted content because of all the sexually exploited children is not seeing the individual trees in what is actually a very complex set of investigations, and they're different investigations in terms of which type of crime is being done. And it ignores, of course, all the ways that people do need to use encryption simply, ubiquitously, easily in order to protect data, from business data to private health data to personal data of any sort.
Oh, these are very good points. We have a question from the audience about the UK online safety bill. So I'll ask if either one of you is familiar with it. The question is, how are these trends of increased privacy consistent with developments such as the UK's online safety bill, which among other groups, journalists say risks hindering their ability to report safely?
So, Eric, if it's okay with you, I'll jump in on this.
Yeah.
So both the EU and the UK have been debating such bills, in part because of the issue of child sexual abuse and exploitation. Although I would say that in the UK, there's certainly a hidden agenda of making it difficult to do end-to-end encryption. And I suspect the same thing is true in the EU, but I am aware of it in the UK. The point is that you can't, as I said earlier, have an evil bit that says, okay, this person is a criminal or a nation state or an adversary trying to get access to the data. And we're going to have really good security. And for this person, they have a legal warrant and so on. Both actions, both in the EU and the UK, are opposed by almost everybody in the computer security community and in the cryptography community because of the problems it poses to security of national security, business security, personal safety, and so on. And you don't see the US jumping on board. There's been no, aside from the FBI pushing this agenda, you haven't seen the action in the US this way. So that's what I would say to that.
Eric, do you have anything to add to that?
I think Susan got it covered very well.
Oh, good. So let's go to the next question, which is encryption a panacea for the protection of personal data and communications?
So I'm going to jump in and say no, and then let Eric give all the details.
Oh, good. Go for it, Eric.
And I totally agree with Susan. I would characterize encryption as a power tool, but you got to use it for the right purposes. You got to use it in the right way. As Susan pointed out, a lot of the failures are in the implementations. We've seen so many times somebody's gone off and implemented what they thought was AES encryption, and they did something stupid in the coding of it. Or they've got some fundamental flaw where they're leaking information, that essentially results in keys being exposed, and the list is long and distinguished, but oftentimes it's down sort of at the implementation level. But there are other techniques that are important. For example, if you're not, I mean, something as basic as securing the platform that you're running on, if it's not secure, then you've got somebody visiting, and then they're able to basically take advantage of some of these poor implementations, or maybe you're forced to use a key in memory temporarily. Well, if you get somebody sitting on the platform and they know what to look and where to look, even though it's there for a nanosecond, they were waiting. So having tight platform security, using appropriate authentication and authorization, and access controls, all of the standard sort of security functionality, you need all of those in place, because they're the wrapper around the encryption that really helps the encryption to be effective. And so it's a whole package, so to speak. And if you don't do it right, it's the weak link is where you get in trouble, and rarely is the encryption itself the weak link. It's, as we said before multiple times, the key management in that suite is usually where the weak link is. But even worse, it can be elsewhere, where you're essentially letting the bad guys in, which I find kind of interesting with the title of this session. The zero trust mantra. You really do need to think about that. And the zero trust is not at sort of like at an email server level. We're getting to the point now where we're thinking zero trust maybe at the component level, as opposed to maybe your phone. It may be components in your phone that are, all right, I need to make sure I've got a trusted relationship with the other components in here. Well, why do you do that? Again, it's back to, I don't know if the rest of this phone's been compromised or not, but if I can protect, this component, then I may be able to protect, leaking of data or doing other sort of nefarious things.
So the White House executive order on improving security focuses on zero trust architecture. Can you just give us a very brief summary of what that is and how that fits into the overall look at encryption and security?
Yeah, so I guess I sort of touched on it a little bit. I think one of the important aspects of zero trust is there's a lot of policy-based activity, and there's essentially enforcement points. So essentially every transaction, whatever that would be, there's basically a check. Are you allowed to do that? Are you allowed to access this? And it's at this point in time. And make no assumptions about the environment you're running on, the platform you're running on, the components you're running on. So depending on how paranoid you are, and I'm a paranoid or insecure security person, so we're seeing that it's a different view. There's no longer this, we've got shields up, we've got firewalls and all these technologies. The assumption is they're a speed bump, they're really not effective. Now, with all that said, it's a fundamental change in sort of how you architect your infrastructure and even your products. And right now, this is primarily a U.S. phenomenon. In fact, a U.S. government activity. And there's an IEEE working group that I'm involved with that is working on some guidance that will, if successful, probably the next 18 to 24 months, result in, at the ISO level, the international level, sort of introducing some of the concepts around zero trust. But it really is very focused right now in the US. A lot of that is communications oriented. So they haven't even gotten to the point from a US government perspective of sort of pulling it all the way into the platforms themselves. Is they're trying to figure out how do we, so we don't trust each other now. Okay, so what does that mean with all of the systems around that? And that's kind of where we're at with it.
Susan, what's your perspective on the question of, is encryption a panacea and also this zero trust architecture?
So encryption is absolutely essential for security, but it is just a technology that has to be wrapped into all the other pieces that Eric started to describe. And he only, he just went over the surface because we're talking to ABA lawyers. We're not doing a 5-day seminar for a bunch of geeks. So it's not a panacea. And as for zero trust, it makes absolute sense. Let me give you a couple of examples. Way back when we had the Sony Picture Entertainment hack by the North Koreans, they got into the corporate network. And then they got access to many other things. They got access, for example, to first-run movies. Now, that was really stupid. There's no reason why not first-run movies, but movies that hadn't been released yet. There's no reason why movies that hadn't been released should be accessible on the corporate network. There should have been a different level of security to get to movies that weren't released yet for whatever executives needed to view them or see parts of them or advertising people within the company. So that's a way of layering. Let me give you a different example. In 2015, 3 different power distribution networks in Ukraine got hacked. And they got hacked within a half hour of each other, with the operators' offices getting shut down, and then the network distribution networks were shut down too. Now, it turned out that they had not ever taken down the physical controls, so they were able to come back up within a half dozen hours, something that the US, the DHS has paid a lot of attention to, because the computer equipment got fried in the attack that happened. But what that tells you is you want, just as Eric was saying a moment ago, you want different layers of controls as you go from one set of the network to another piece of these systems, so that as you get to a different place in the network, you say, are you really authorized to be here? Prove to me you're authorized to be here right now. And that's another form of protection. It's one that we always thought of things as either you're outside the network and we don't trust you, or you're inside the network and then you can do anything. And what Eric is describing with zero trust is, well, there's this piece of the network where you can do these things. You want to get over here? We need to see that you actually have authorization. You have authorization to go into the principal's office, that's fine, but you need authorization to go into the treasurer's office, a different level of authorization for that. And that's what this is the analogy of.
Susan, you'll be very interested to know that there's a group of people in the ABA who are very technologically astute. And I think a lot of them are on this call. Some of them have engineering degrees, they're computer scientists, in addition to being lawyers. So
yes, no, I know I've met some of them and they're great. I just meant we're not doing a geek seminar, so we're trying to not be too geeky.
Absolutely, but they appreciate all the details that you and Eric are providing about these complicated issues. So let's go to our important final question, which is, given the current state of technology and encryption, in your opinion, what would be the best, most appropriate and technologically feasible regime for protecting confidential and personal information? So do you want to start, Susan?
No, but I will try anyway.
Oh, well,
So I think the executive orders that have come out of the Biden White House are an important step in this direction. We are a very anti-regulatory nation. And if you look at the Biden orders, one of the things they say is, if you're a contractor for the US government, these are things you have to do. And one of the important aspects of that is, if you're going to do that in your contracting with the US government, well, now you have these technical tools and your other customers are going to demand it. That's a way of slowly pushing improved security. But it's very slow. And I agree completely with Eric that you don't say which encryption algorithm, you say an appropriate level of security for data. But I think we have been remarkably slow on the legal and regulatory front for expecting reasonable levels of security. The FTC is stepping up its game a little on privacy, but it's an underfunded and under-resourced agency. And it needs to have greater resources in both terms of personnel, in terms of legal capability, and in terms of funding. But till we have the regulations and requirements in place, and I'm not talking again about specific requirements, but an expectation, we're not going to have the right level of security.
So what kinds of regulations and laws and approaches are you working on recommending, or what do you think should be done?
So I've been focusing more on the privacy side of late rather than the security side. And on the privacy side, I've been most concerned with telemetry and metadata that I mentioned earlier. And there I would like to see, with narrow exceptions, no secondary use of the data. So use it for quality of service, use it for anticipating future business needs, use it for security and against fraud. Those are all appropriate. Use the data in public health emergencies, such as where are people fleeing to during an earthquake or a flood. Very appropriate for a short amount of time. We're not talking months, we're talking week. Use it for research that's peer reviewed in the public interest and where the data is de-identified, perfectly appropriate. But there, I would not see secondary use in the data, because it gets too much private information about individuals that individuals don't have the capability to control the collection or use of. And that, of course, has both privacy implications as well as security implications. But my focus in the last couple of years has been on the privacy side. So I'll bat this over to Eric for some comments on the security side.
Yeah,
Go for it, Eric.
Yeah, and my observations, again, as I said earlier, privacy does seem to be a pretty serious driver in terms of what we're going to basically do on the security side, because you really can't have privacy without some aspect of security and encryption. If you look at the security side, we don't need no stinking privacy, kind of attitude at some point. So security is basically being invoked through the privacy mechanism. I think from a regulatory perspective, though, if you're going to talk about security, you really want the language to be around risk-based approaches. You don't want to say, ideally, you don't want to say things like reasonable. So let's be a little more precise. Force organizations to actually look at their situation, look at their data, and then that they handle it appropriately. Because if you do that, then if they aren't doing what they're supposed to be doing, you have an ability to basically take them to task. And the legal community is quite good at doing that. And we're beginning to see, for example, in the case of IoT, that some of that kind of language, some of that behavior is starting to show up. California, has taken some steps in this space. The Biden administration has come out recently with looking at a consumer IoT labeling program, labeling in the sense of, this is looking at the security, for consumer IoT. So I think we're starting to see that this risk-based approach is becoming more commonplace. And then the role of encryption is, back to, well, is it appropriate or not based on, the kinds of data that you're dealing with, the kinds of transactions and stuff.
Eric, can you point us to any of the standards that you're working on that reinforce this risk-based approach? And is this what NIST is trying to do in the cybersecurity framework?
So, yeah, the short answer is there are lots of ISO standards around risk. I like the NIST documents primarily because they're freely available, and they're not always perfectly aligned with what's happening in the ISO space. But if you can get your hands on documents that give you insight into what you should be doing, you should be looking at. So the NIST, for example, the 800 series are quite good. You mentioned the cybersecurity framework. There's also work that NIST has done in AI and dealing with IoT. So they're looking at risk in a bunch of different areas, and any of those documents, if they're relevant to you, I think would be worthwhile looking at. There are a lot of ISO documents. I head up the U.S. committee that interacts with the ISO committee that deals with information security, cybersecurity, and privacy protections. I think the count at the moment is there's 330 documents that committee has ISO committee has produced. So that's a lot of material, to go through. I think we've got something on the order of 70 standards that are currently under development. Very active area in covering all of cybersecurity and whatnot. So, but if you're new to the topic, you need something, I always recommend start with NIST materials, and then if you're US based, that's a good start. If you're a multinational, then you can probably jump off into sort of the ISO, but you'll at least figure out what you potentially need, from looking at some of the NIST materials.
So Susan, we'll give you the last word here. Can you point the audience to any specific proposals that you're working on, and also give us your thoughts about the post-Dobbs situation with the prosecutors trying to get personal information from doctors and women and others in order to prosecute them for abortion-related cases?
I think it's, to take the second question first, I think it's really close to impossible to function in the modern world without leaving your data everywhere. So I was a very late adopter to cell phones because I really liked the freedom not to answer calls at all times. I know I could keep my phone off, but that sort of obviates the purpose of the device. But there I was when my flight got canceled or delayed a lot, and my local airport, which is a reasonable sized airport, had 2 payphones left. So I didn't have a choice. We don't have a choice not to have a smartphone because of all the myriad ways that information is sent to us, including needing the phone for taking photos of documents to show wherever you are and so on and so forth. So we don't have a choice about carrying those devices with us. But then, as I mentioned, a user doesn't have the ability, the technical ability, the intellectual understanding to understand and control the data that comes off of it that a really determined prosecutor could use against somebody. And as I said earlier, it's not just GPS, it's magnetometer, accelerometer, gyroscope, but other kinds of data too. We fortunately don't live in a state which has the following problem. But if you're marching in a protest march, the networks you pass by where your phone says, hello, are you a network I can connect to? Hello, are you a network I can connect to? Well, if I and my husband or I and a coworker are walking past those networks, the networks recognize that we know each other because we happen to have the same networks in common. And so there are all sorts of ways we leak information to all sorts of places that we're unaware of. I mentioned the proposal I'm working on privacy. I'm also working with various people on preventing the client-side scanning attempts. That is the idea of scanning information on your phone to see whether or not you have forbidden material. In this case, the forbidden material is CSAM, child sexual abuse material, but one can easily imagine other states using it in other ways. So those are the ones I've been working on of late. But I think we're in a situation where the technology, as we all have said for decades now, the technology has so far outstripped our understanding and our legal and regulatory ability that we're in not a great place now, although there's finally recognition in various ways. I think GDPR, the General Data Protection Requirement, is one such, and we're seeing more attention. The Biden administration is another. And so things may be finally moving in the right direction, both in terms of security and privacy.
Thank you, Susan and Eric, for a fascinating discussion. I'm going to turn the program over to Ruth for some concluding remarks.
Well, thank you. Those 60 minutes for our program just flew by. We'd like to thank all of you in our audience for your attention and terrific questions. We tried to answer as many as we could. We'd also like to thank our distinguished panelists, Eric Hibbard, Susan Landau, and Lucy Thompson. On behalf of the American Bar Association, the Civil Rights and Social Justice section, and the Science and Technology Law section, I thank you for joining us and encourage you to register for the last webinar in this three-part series called Zero Sum Game, Developing a Winning Approach to Privacy and Security in an Age Zero Trust. On July 20th at 1 p.m. Eastern, visit ambar.org/encryption for more information. And both of our sponsoring ABA sections provide webinars, publications, and other resources for attorneys, business professionals, and advocates nationwide. Members receive so many benefits, so please consider joining and becoming active in the ABA and these sections. You can do that at ambar.org/CRSJ and ambar.org/SciTech. Thank you so much for joining us.